Hello fellow YouTubers and especially my fellow Queenslanders. Whilst given this opportunity, I'm pleading with YouTube administrators to not shadow ban my complaint, but to help make this example of corruption common knowledge. My story is proof positive that cronyism and corruption can easily be promoted if ignored within the Westminster system of justice if those that dispense justice are all associates with vested interests. I have been forced to produce these videos as there is no other way of exposing the truth, as the Judiciary, with all their talk of ethics etc., will never acknowledge blatant corruption amongst their peers. Remember, it is perfectly legal to criticise a justice guilty of corruption, as the evidence is clear. As an individual, you're powerless, you're dispensable, being muted and denied before the scales of Lady Justice there is literally no words to describe the suffering. Journalists, by definition, their job role is to hold the establishment accountable, but not in my case. They have all been made mute. It's Queensland's dirty little secret. Nothing is real, and who would have thought the press would play along? My experience proves those thinking people amongst us must question everything portrayed on the media. Teach your children to be skeptical, as just because information is presented to you on your iPhone, it doesn't make the story factual or real. It is a very important life skill, and here are some free legal advice for the legal fraternity in Queensland. Life isn't hard to manage when you've nothing to lose. I suspected I was being swindled in the Supreme Court in 2011, but could not distinguish the difference between legal procedure and the pugnacious attitude of the respondent's lawyers, acting on behalf of Lexon Insurance. I began copying documentation to the Crime and Corruption Commission in the same year. I discovered the truth in early 2015 that I was the net beneficiary of the law, and those involved had deliberately paraphrased the law to mislead. I filed a complaint with the Parliamentary Crime and Corruption Committee, and that too proved to be a whitewash. I was interviewed confidentially via a phone call and felt the investigator empathised, but 3 months later I received a letter in the mail claiming Justice Peter Lyons was immune to prosecution. In early March 2020, I discovered I could prove deliberate intent by Justice Lyons and his cronies to mislead immediately after he provided a winning judgment in our favour on the 4th of April 2012. The optics of the event, from my point of view, were completely different to what occurred in the courtroom. Justice Lyons provided a winning judgment dismissing a summary judgment application by Lexon Insurance on the 4th of April 2012. Our lawyers forwarded a prepared order to Justice Lyons immediately afterward, who then refused to seal the document, suggesting he would seal such order at a cost hearing, which was set down on the 28th of April 2012. At that hearing, Lexon's counsel informed the court that they had lodged an appeal in the Court of Appeal. Justice Lyons stated, "There was no need. Let's set a date to hear your grievance." Then conveniently, the date, the 2nd of May 2012, was set. On the 2nd of May, a new Queen's Counsel appeared on behalf of Lexon Insurance and put forward a new argument suggesting the 1978 City of Brisbane Town Plan superseded all new town plans. After 3 hours of convoluted oral arguments, it appeared as though Lyons then overturned his original decision of 4 April 2012. He overturned his own original correct argument with one he must have known was false. Early in 2020, the evidence found in the court file shows Lyons sealed orders against our family on the 20th of April 2012. It is impossible to reconcile considering we won the proceedings on the 4th of April 2012, only 16 days earlier, and appears as though our own counsel must have been aware of that fact, which means the hearings that occurred on the 28th of April and the 2nd of May 2012 were a charade. No wonder they sounded convoluted. I had always given my own lawyers a free pass, not realising that they were treacherous. Who would think that was even possible? They billed us hundreds of thousands of dollars in fees proving our $1 million claim against Lexon Insurance, the professional indemnity insurer which is owned by the Queensland Law Society. To reiterate, the evidence shows our lawyers ignored an original correct judgment on the 4th of April 2012 by Peter Lyons. Lyons had provided a winning judgment in court, but then immediately refused to seal an order acknowledging it in favour of our family. I discovered the court file shows the original judgment was never entered or acknowledged. Our lawyers then assisted Lexon Insurance lawyers, and Justice Lyons overturned the original correct decision on the 2nd of May 2012 with a decision everyone in the courtroom knew was false, except for me. They participated in a charade, and the original version 1 of the transcript proves it. It is the type of situation a fiction author would have difficulty dreaming up. To be swindled in a courtroom is devastating when you realise the truth of the deception. In 2014, I discovered I was a net beneficiary of the law, and the original decision on the 4th of April 2012 was correct. But the legal fraternity, the Parliamentary Crime and Corruption Committee, and the Crime and Corruption Commission insinuated that I needed to prove intent. At the time, the correspondent simply stated he was immune from prosecution, which was irrational when you understand the significance of the accusation. It was a cover-up. I have remained in constant contact with all the authorities, including the Queensland Premier's office, and rarely received a response. They kept ignoring me and continued to kick the can down the road. The cover-up was initially instigated mid-2015 by the former head of the Crime and Corruption Commission and supported wholeheartedly by the Premier of Queensland, Anastasia Palaszczuk. It is absurd to suggest she was not aware of my complaint. The Leader of the Opposition has also conveniently preferred to ignore my claim, as he too is a lawyer, and his commitment to the Illuminati comes first, and the people of Queensland come a long distant second. I can't imagine a worse crime. After the loss in the Supreme Court, my own lawyers then insisted on receiving another $80,000 in advance to take my matter to the Court of Appeal. When in hindsight, I now know every lawyer in that courtroom knew I was a net beneficiary of the law, but cronyism guaranteed a loss. The transcript of the proceedings in the Court of Appeal before 3 justices proves my lawyers never argued the reasons we won the original proceedings in the Supreme Court on the 4th of April 2012. On Monday, the 4th of October 2021, 3 months after submitting evidence to the Legal Services Commission, which is irrefutable, I received letters suggesting my complaint is out of time, and to pursue those involved wasn't fair. These letters can be found at our website www.whentheftislegal.org. The audacity is breathtaking. These proceedings cannot be considered an ordinary transgression. The result is in direct conflict against everything we as Australians hold sacred in a democracy. The right to a fair trial and due process is paramount. It is a basic human right, and clearly the outcome was manipulated in both the Supreme Court and the Court of Appeal. Written legislation must mean something. What is the point in drafting legislation if those dispensing justice can simply collude with other advocates to secretly destroy an innocent party to assist an associate and save Lexon Insurance from paying out a legitimate claim? That was proven by forensic accountants, valuers and town planners, etc., against another negligent lawyer. They are all associates, friends, presiding over a professional indemnifying insurance company that is owned by the Queensland Law Society. It is obvious it's a massive conflict of interest. Talk about snaps in a trough. A brief explanation of the evidence. It proves our matter was predetermined as early as 2009. In mid-2009, our lawyer insisted I employ a Queen's Counsel at $1,000 per hour specialising in property law to provide an opinion on indefeasible title. I was given a choice of two property experts, one of which was Peter Lyons QC. I was then advised I must employ the other QC as Lyons became a Supreme Court Justice. That opinion cost approximately $30,000. I now know they colluded to ensure that opinion was wrong and also conveniently admitted the transitional section of Section 22B of the 78 Town Plan. It was no accident. The main defendant was Rod, the senior property partner of Brisbane's largest law firm. Rod had an intimate relationship with a handful of QCs specialising in property law, and they ensured I suffered Rod's fate. Arguments were heard in October 2011. Lexon Insurance had filed an application seeking summary dismissal based on that opinion penned by the QC, which had ignored the transitional Section 22B, Section 1 of the 1978 City of Brisbane Town Plan, which stated the 78 Town Plan simply did not apply. Justice Peter Lyons was forced into providing a judgment which was correct in law. The Integrated Planning Act did apply retrospectively to 11th of June 86, and our lawyers were naive to that fact. Secretly behind the scenes, Justice Lyons suggested that the 1978 Town Plan did apply, which was false. These documents can be found at whentheftislegal.org. The original judgment of 4th of April 2012 was never sealed or entered into the original court file. At no time did our lawyers ever consult or advise us that the original judgment was somehow to be ignored and it was irrelevant, which amounted to a lack of disclosure, and it was never entered into the court file. During proceedings on the 2nd of May 2012, Justice Lyons sought to adjourn for a lunch break before the ultimate outcome, where Lyons overturned his own original correct decision. Our lawyers and I returned to our lawyers' offices at the Inns of Court in Brisbane. During that walk, my lawyers indicated that it wasn't fair that Lexon Insurance was offered a second bite of the cherry, and then stated they lie. I offered to buy us a takeaway lunch, then upon entering the office, after several minutes, the senior lawyer offered me the 1978 City of Brisbane Town Plan at Section 22B. Here, see if you can find something. As a layperson without legal training at the time and not understanding the first clause in the transitional Section 22B was known as a definition section. Section 2 seemed to contradict subsection 1. It simply baffles belief that both lawyers in the room did not know or understand that subsection 1 was known as a definition clause, meaning it defined what that entire section's purpose was. At the time, I remember thinking, why are you giving it to me? You're the lawyers. That afternoon, an hour into proceedings, Justice Peter Lyons overturned his original decision. Then Lyons remained seated at his podium. My lawyers packed up their files and left the courtroom. Doesn't that seem a little strange? Typically, a justice packs up, walks to an exit, looks to the court, then his courtroom colleagues bow. He bows in return. That did not happen in this instance. I remained seated in the gallery contemplating how to approach my ex-wife with the news that we'd just lost everything. Justice Peter Lyons waited until the Lexon Silk approached the bar and then stated, "May I suggest you now withdraw your appeal application," to which they both, Justice Lyons and the Silk, both chuckled. At the time, it never crossed my mind that we had just been swindled. My lawyers, as legally trained advocates of the law, should have challenged functus officio with that knowledge, and that Justice Peter Lyons, as an administrator of the law, cannot overturn his own decision on the 2nd of May 2012 unless they were complicit with Lexon Insurance and Justice Peter Lyons' predetermined outcome. Let me explain. There are very few rules as to how a justice conducts himself in a courtroom. However, there is one important rule, functus officio. It is an ancient Latin term that means once an administrator hands down a decision, his job is complete. You will find the definition of functus officio at our website whentheftislegal.org. It makes absolute sense, as why else would there be a need for a court of appeal if judges can simply change their mind? It is the only reason the Court of Appeal exists. It is self-evident that these proceedings were predetermined and engineered. My lawyers must have been aware of the outcome, especially when, as trained advocates of the law and acting on our behalf, they must have received copies of the sealed order against us on the 20th of April 2012, all the while having knowledge that we won the proceedings on the 4th of April 2012, just 16 days earlier. It's absurd. Lexon on the 24th of April 2012 submitted another application seeking another summary judgment, which was technically the third time they did this. However, this time it was with the assistance of my lawyers. The evidence, the actual transcript, demonstrates those involved were play acting. There is a famous movie called Dirty Rotten Scoundrels. Does that ring a bell? On the 4th of October 21, I received letters from the Queensland Government's office, the Legal Services Commission, that claimed I am out of time and that it is unfair to hold those responsible. Is beyond absurd and cements the Commission's participation in the cover-up. There is no point in the Queensland Government legislating any matter or decision if it can simply be ignored by those with a vested interest or to protect friends or the legal industry's integrity. 1 year ago, approximately on the 15th of December 2021, an independent journalist promised he would expose the Premier and what the Judiciary did to me. He organised a confidential appointment with a specialist property lawyer that would investigate and confirm the facts. I met the lawyer at his home. He interviewed me for over an hour and he has understood every aspect of the criminality. He got it. The reality is that you don't need to be a property lawyer to understand that the obvious crime was functus officio. The lawyer looked at me, boasting a large grin, and he clapped his hands together like this, in reverse, pushing out, and stated, "Let's take down the Premier." I was so overjoyed, because finally I found someone that would help expose the truth. I left him with a 2-volume dossier, 2 of these. For the first time in many years, 3 weeks later, I followed up. After receiving an email, he advised me he too was too busy to help. I couldn't believe it. The Illuminati had got to him. He refused to meet me and left the files on his front veranda, advising it was my story to tell. I have been complaining ever since I discovered the truth to every Queensland government department whose purpose is to prevent corruption within the public service since early 2014, including the recent Fitzgerald inquiry of 2022. Although their response claimed that the corruption within the Judiciary was not within the terms of reference, which is laughable. Isn't that convenient? As these people never start an inquiry unless they know the outcome before they start. I recently discovered some underlings within the Queensland Law Society also asked for an inquiry into the Judiciary in Queensland during the last election cycle last year. However, you can be guaranteed that was quickly knocked on the head by the Premier. 2 months ago, the final piece of the puzzle fell into place. Remember, there is an old saying, 95% of lawyers give the rest a bad name. When is a judgment if it is not sealed or ever acknowledged in a court file? They could say it was irrelevant because it wasn't acknowledged or confirmed. It was all an illusion. I discovered on the day my lawyers appeared before Justice Lyons on the 2nd of May 2012, they made one fatal mistake. Their submissions to the court that was shared with Lexon Silk and to the judge referred to the original judgment of the 4th of April 2012. It means that Justice Lyons was given a copy of his original judgment the day he overturned it with another judgment he knew was wrong. Functus officio. Snap. Got you, you bastards. You're guaranteed a fair trial and due process unless you can prove you didn't get one. This video is designed to give you a quick overview of the obvious sleight of hand. He was paraphrasing the law. I thought we could start a Me3 movement on Twitter if you have been deliberately wronged by the judiciary anywhere in the world, including England, Canada, New Zealand, or anywhere practicing the Westminster system of justice, and that you visit www.whentheftislegal.org to force the Queensland government into establishing a royal commission into corruption within the judiciary in Queensland via change.org. Please remember to like every podcast so we improve its distribution around the planet, and please subscribe to my channel. It is very important as we need to expose the Queen of Cover-Up, our Premier, Anastasia Palaszczuk. And if inclined, please leave a donation to help fund this venture as I need help. See you again soon, and always remember, she'll be right, mate. Never fear, Randolph is here. Kia ora. That's for our Kiwi friends in Queensland.